Good morning, friends. We have discussed Section 65B of Indian Evidence Act several times in this channel. We have always debated on whether Section 65B certification is required or not required, and if so, who has to give it and how it has to be given. Now, subsequent to the Supreme Court judgment of P.V. Anwar versus Bashir, the matters were reasonably clear that Section 65B certification is mandatory whenever an electronic evidence has to be admitted, and admissibility is a process different from discussing the genuinity of the electronic document. Therefore, Section 65B set conditions for admissibility, and it is always open to the defendant to challenge the genuinity of the particular document, and the process of discussing the genuinity could be different in the sense that at the time of admissibility, if the certification is in order, the electronic evidence needs to be admitted. It is possible that the same electronic document may be submitted in a different form by the defendant, and he also may bring in a Section 65B certification from another person. In that instance, there will be one 65B certified electronic record versus another Section 65B certified same electronic record. If there are differences, obviously one of the certifications would be incorrect, or the certifications may refer to a different point of time or a different context. We know that electronic documents are not documents like, say, a PDF document existing in a particular store and it is retrieved or kind of a thing. Such documents can also be there, but many times the documents on the web, for example, a Facebook page or a website, the content actually is dynamically collated when a visitor visits the website, and the website is most of the time programmed to check the visitor, particularly the country from which he comes, the time of the day at which he is visiting, based on which certain contents, including the advertisement surrounding the basic content, would be changed. Therefore, the electronic document which is seen by a person at one point of time and another person at a different point of time could be different. So there is a possibility that two Section 65B certified electronic records may exist without any malicious intention on the part of either of the Section 65B certifiers. There can also be a situation where one of the Section 65B certifications is correctly, honestly given, whereas the other may be a result of a modified data, which could be either malicious or it could be an honest error. For example, if the litigant has managed to alter the data and ask an independent certifier to certify, he would obviously certify that as he is able to observe. So this Section 65B certification was considered as an essential feature of admissibility of electronic documents. Now, this position, of course, was first introduced in the year 2004 when I submitted the first Section 65B certificate in the case of Suhas Katti versus State of Tamil Nadu, or State of Tamil Nadu versus Suhas Katti, which was a criminal case under Section 67 of Information Technology Act. the allegation was that there was a message in the Yahoo group which was defamatory and obscene against a lady who had filed a complaint. Now, the piece of offense was sitting in the Yahoo server in the form of one of the many messages which were there in groups.yahoo.com. And for the purpose of the case, I had visited the group.yahoo.com, viewed the particular document on my computer, taken a printout, and given a certificate that after I follow a certain process, a document appeared on my computer, and this is the printout of this particular document. And that was at that time accepted as the valid Section 65B certificate. My certificate was not related to the certifying of the content, as whether the content was obscene, whether the content was, say, defamatory, and so on. Those were the things which the IO in that particular case had to explain to the court, and the court had to accept it. But the fact that the content was presented to the court in an admissible form through a Section 65B certificate from a person who is not necessarily a government forensic expert was established in that particular case. In fact, at that time, Section 79 capital A of ITA 2000 was also not there. Now, this Section 65B understanding had been continuing. Subsequently, there was this Arjun Panditrao case, which actually endorsed what was there in the Anwar case, but suggested that something has to be done to have more clarification or whatever was that. But the views of the Anwar case persisted until now. Now we have come to a situation where the Indian Evidence Act has been replaced by Bhartiya Sakshya Adhiniyam, and therefore a new section has come into being called Section 63, which is the counterpart of Section 65B. And obviously we need to discuss whether the Section 63 is same as Section 65B or something more, and the discussion has started just now. Section 65B discussion went on for years. The Suhaskatti case was 2004, and the Anwar clarification from the Supreme Court was 2012. So it took 8 years for some case to reach Supreme Court and Supreme Court to give out its judgment. So this Section 63 also may have to undergo a discussion at different courts before perhaps more clarity will be available. Now, obviously, the lawyers are worried, concerned about how do we proceed with the documentation of an electronic evidence. And actually, we had a discussion yesterday on 13th of July at Chennai. And some deliberations did take place, but as it always happens, it is difficult to come to a conclusion because these changes are done in such a manner that the law itself is not very clear, or maybe the words are used little loosely, so it can always be creating more confusion than it is supposed to sort out. So that situation prevails. So what I am trying to do in this particular talk is to provide more clarification as I see it on Section 63. It is not necessary that what I say today is the final word. We may have to still debate on this and then perhaps arrive at a more acceptable say explanation of section 63, but I am anyway going to place my views for further discussion. Now, section 65B actually came in Indian Evidence Act after the Information Technology Act 2000 was notified from 17th October 2000. Now, in that act, they had started with section 3 to say, this is we are talking of section 3 of Indian Evidence Act, to say that evidence includes electronic records. Then there was a section 17 which defined admissions to include electronic form of admission in addition to oral and documentary admissions. Then there was a section 22 capital A which stated that oral admission is not relevant for electronic records. Then there was a section 59 which said also that oral evidence is not applicable to electronic records, because after this series 59, 60, 61, they were about how oral evidence can be presented, how documentary evidence is presented, like that. So under section 59, it said oral evidence is not applicable to electronic records. And it went on to describe how a documentary evidence can be presented as a primary document and in certain cases as a secondary document. But that applied to the category of documents which were not electronic records or electronic documents. Then it went into section 65A, which said that this is a special provision for electronic document, and said electronic documents will be admissible as per section 65B. So therefore, we came to section 65B as a special provision applicable to electronic documents. There was no confusion about whether electronic document is paper document, whether the conditions of admissibility of paper documents or documentary evidence in general is also applicable here. This confusion actually was not there in the section earlier Indian Evidence Act and the section 65B. Now we have this Bharatiya Sakshya Adhiniyam, BSA 2023, which has been notified with effect from 1st July 2024, along with the new IPC, which is Bharatiya Nyaya Samhita, and the new Criminal Procedure Code, which is Bharatiya Nagarika Surakshana Samhita, or BNSS. Now, in this version of Bharatiya Sakshya Adhiniyam, the earlier sections of 17, 59, 65A and 65B of Indian Evidence Act has been continued, but under a different section number 15, 54, 62 and 63. Section 22A appears to be absent in this new act. Now, for better clarity, let us just see whether there is any difference between the earlier sections and this. Now, if you look at the section 3 of Indian Evidence Act, which said evidence means and includes all documents, including electronic records. And it said such documents are called documentary evidence. Now, the definition section under the Bharatiya Sakshya Adhiniyam 2(1)(d) and E says that document includes electronic and digital records. So that goes with the last line on the second, on the left side. Then evidence means and includes all statements, including statements given electronically, which the court permits. I don't know whether this means that the court cannot permit in certain cases. Anyway, all documents, including electronic or digital records, produced for the inspection of the court, and such documents are called documentary evidence. So there is still in this section 3 and section 2 here, a kind of terminology overlap by saying that this evidence, which we are talking of as digital record, is a documentary evidence. Whereas I said that in the earlier record, when we come to admissions, which will come, they distinguish three kinds of admissions, one of which is electronic records. The earlier section 17 of Indian Evidence Act said that an admission is a statement which can be oral, which can be documentary, or it can be electronic form. So it was very clear that three types of admissions were permitted, one of which was oral, one of which was documentary, another was electronic form. Now, if admission in electronic form is a digital record, there is no reason why we should now say that digital record is a documentary record, because it only confuses us more. But anyway, we'll keep that aside. So section 17 was what is given here on the left side. Now the section 15 of the new BSA says an admission is a statement, oral, documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons or under the circumstances hereinafter mentioned. So here also they are talking of three kinds of admissions, oral, documentary, and contained, and in an electronic form. This is where I said in the earlier Indian Evidence Act, they clearly said the procedure for admission of oral statements is this, procedure for admitting the documentary items of this, and then they went into electronic documents. So there was three clear compartments. There was lesser confusion. Now this section 22 capital A, which earlier said that when an oral admission is given as to the contents of electronic records, they are not relevant except under a circumstance where genuineness of the electronic record is in question. That is, when the electronic record is admitted and subsequently contested, then there may be a need for somebody to come and orally speak about the genuineness of the document. And at that time, oral evidence could be relevant, otherwise not for the proving the fact contained in the content. Now, in the BSA, there doesn't seem to be a corresponding section, so we will leave this for the time being. Now, in the earlier Indian Evidence Act, because there was a strict compartmentalization of procedure for admissibility of oral evidence, procedure for admissibility of documentary evidence, before the Act went into procedure for admissibility of electronic evidence in the form of Section 65B, there was no need for us to look at the sections in which primary document was defined, secondary documents were defined, etc. Because technically speaking, we always know that in the case of a digital document, it is always a secondary document which is available for the purpose of evidence. Why do I say this? Primary document in a computer is, let us say, is the document which goes into the RAM. The RAM captures that. And subsequently, RAM transfers it to the storage device. Now, the RAM evidence or RAM whatever content is volatile in the sense that it is not available for future reference if the computer is switched off. Now, if you look at Information Technology Act, Section 4, which I will show before and then I will come back here. Let me just move on to this section 4 of the ITA 2000. It talks about legal recognition of electronic records. And it says that where any law provides that information is to be given in writing, etc., it is deemed to be satisfied if such information is rendered in electronic form and accessible so as to be usable for a subsequent reference. To me, this particular section appears to suggest that if there is an electronic form document, if it is not accessible or is not meant to be accessed to be usable for a subsequent reference, such temporary documents are not having legal recognition, and therefore they are not even legally should be recognized as evidence. This can be contested, but this is one of the views. And what we say in Evidence Act, that evidence includes electronic form, has to be subject to the recognition in the first place. So therefore, the documents which cannot be accessible and usable for a subsequent reference should not be considered as, let us say, valid or legally recognized electronic document, nor evidence. Now, if you keep this particular thought in process and then come back to this particular section, we are now in a dilemma about how to deal with the record which first goes into the RAM. Now, that's why earlier we used to say that anyway RAM is going to be the first place of the record creation, which you can say is the primary creation, and then it goes into a storage. So every storage of electronic document is a secondary document. Therefore, in the case of electronic document, we should not give too much of importance to what is primary, what is secondary, and everything is secondary. And because the Indian Evidence Act talks about a special provision with reference to the admissibility of an electronic evidence without referring to the primary, secondary nature, we were clearly of the opinion that this primary and secondary is not applicable to electronic documents. In the case of electronic documents admissibility, go directly to section 65 capital A and say that the condition specified in section 65B, if it is fulfilled, then it becomes admissible. But now in the Bhartiya Sakshya Adhiniyam, there is a confusion which has been introduced. Because here section 57, which precedes the section 62, which is equivalent to 65A. Okay. What is section 62? Let me see. See section 62. It says the contents of electronic records may be proved in accordance with the provisions of section 63. This was what section 65A said earlier, that contents of electronic records may be proved in accordance with the provisions of section 65B. And because of this provision, in the Anwar case, the Supreme Court said that section 65B is a complete code applicable to the admissibility of electronic evidence. And because of that, there was actually no need to discuss about the previous sections with respect to the primary and secondary evidence. But now, this section 57 of the BSA talks about primary evidence, and it uses in the explanation some electronic evidence. For example, Section 57 says that primary evidence means the document itself is produced for the inspection of the court. That is fine. But when we go to the explanation 4 says where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is a primary evidence. So what this means is that BSA recognizes the existence of primary evidence in respect of electronic documents, and it also recognizes the presence of multiple primary evidence instances. Now, earlier, I think the courts were talking about books when the kind of printed books, they used to say that every copy of the book can be taken as a primary evidence. So similar thought seems to have crept in here, that multiple copies of the electronic document can be considered as primary evidence. And explanation 5 says where an electronic record is produced from proper custody, such electronic or digital record is primary evidence unless it is disputed. Then explanation 6 talks about a video recording, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another. Each of the stored recordings is a primary evidence. Explanation 7, where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. So, Section 67 says that even temporary files can be considered as primary evidence. We don't know what was the thought behind this. When they talked about temporary files, whether they took into consideration the existence of Section 4 of Information Technology Act, which actually did not give legal recognition at all to such electronic records which were temporary and not available for future reference, we do not know. So this is one of the areas which will expected to create problems. This was perhaps introduced for some use case, like a TV broadcast, which can be recorded anywhere at the destination, could be brought into evidence. But when you apply this to a normal computer operation, it means that RAM data is also primary evidence stored in the hard disk is also a primary evidence. And if the program is creating simultaneous recordings, for example, you are in a Zoom and then say that you record it on the cloud and simultaneously a copy is recorded on your computer, both become primary documents. So this creates a situation where there are multiple primary documents. Now, one way of looking at it is that since there can be many primary documents, the need for secondary documents with certification can be considered as reduced, which means that you don't require a Section 63 certificate carrying the document for presentation, because anytime a document is available in primary state, it is not required to produce the secondary document. Now, secondary evidence, of course, includes certified copies given under the provisions hereinafter contained, which goes into the Section 62 and Section 63. Now, it also says under Section 58, oral accounts of the contents of the document given by some person who has himself seen it is also a secondary evidence. And then oral admissions is also secondary evidence. So secondary evidence includes certified copies, oral accounts of the content of a document. Suppose I say that I saw a document which stated A, B, C, D, E, then that also becomes a secondary document, then any other oral admission. So removing 22 capital A of the earlier act and in section 58 adding these oral accounts and oral admissions has brought in oral admissions also as a secondary document. Now, in the Afzal Guru case, there was a question, and in fact, at that time, the court accepted the oral evidence without Section 65B certification, more or less similar to the Section 58, subsection 5, which is shown here. That was more or less the same use case there. Now, in order to provide authentication to that Afzal Guru case, which was actually in the Anwar case, the court did mention that it was a mistake. Okay. Now, they are trying to put this clarification under section 58, which is again something which means that in this case, then both because primary document production is possible and because the oral admissions can be considered as secondary evidence, probably the need for section 63 certification has been significantly reduced. Now, whether we can say section 63 certificate is mandatory or not is itself going to be disputed. In many cases, the litigants will not produce section 63 certified copies. They will either say that I have a primary document, please accept it, or they will say I will bring a oral account of the document, accept it as secondary evidence because the person is coming there as a witness, and therefore there is no need for section 63 certification. So probably this is what I think many advocates wanted, because they were uncomfortable with section 65B certificate and they wanted that to be done away with, and to some extent section 58 appears to move in that direction. Now section 59, equivalent to the earlier section, says document can be proved, shall be proved by primary evidence except in cases hereinafter mentioned. We know that the secondary evidence is acceptable only in certain cases, like when the primary document is impossible to be presented or destroyed or something like that. So similarly, in the BSA also, there is section 60, which talks about conditions when secondary evidence may be given. Well, like this, where when the original is destroyed or is out of reach, etc. Maybe one of the conditions which will come directly here is when the primary evidence is in the Yahoo server, you cannot bring the Yahoo server, therefore secondary evidence condition is fulfilled. Now section 61 of BSA says nothing in this Adhiniyam shall apply to deny the admissibility of electronic or digital record on the ground that it is an electronic or digital record, and shall be subject to section 63. Now, basically, this section 61 is trying to ensure that the electronic record will not be denied admissibility. Okay. Now we go into section okay, before we go to section 61, 62, this section 59 of the earlier Indian Evidence Act has now an equivalent of section 54. Let me just point out the relevance of this. Section 59 of Indian Evidence Act said all facts except the content and documents of electronic records may be proved by oral evidence. So apart from 22 capital A, in section 59 it was reiterated that oral evidence as to electronic documents was not acceptable. Now, in section 54 of BNS, all facts except the contents of documents may be proved by oral evidence. Now, if you say, as we saw in an earlier section, that electronic record is also a document, is a statement in the BNS. Okay. If you say that, then all facts except the contents of even electronic documents may be proved by oral evidence. Okay. So we are now in a situation where oral evidence is permitted. Now with this, if we go to section 62, which is a replica of section 65A, it says that the contents of electronic records may be proved in accordance with the provisions of section 63. So section 63 becomes the code under which we are going to discuss how the admissibility of electronic records will be worked out. Now, if you look at section 63, again, it has got 63 subsection 1, 2, 3, 4, 5. Now, the most important aspect of the earlier section 65B as well as the current 63(1) is to understand the scope of section 63. If section 63 is a code by itself, 63(1) defines the scope of this code. Now, what does it say? It says, notwithstanding anything contained in this adhiniyam, any information contained in an electronic record, which is printed on paper, stored, recorded, copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device or otherwise stored, recorded, or copied in electronic form, in bracket, hereinafter referred to as computer output, shall be deemed to be also a document. Again, the word document comes here. Okay, it could have been said is also an electronic record admissible as evidence, but they somehow bring in the word document here. If the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original as evidence or any contents of the original or any facts stated therein. Now, this section recognizes that there may be a original, and we are saying that without production of the original, you can accept this, whatever is discussed in section 63. So, the existence of a section 63 certified document, which is an acceptable replacement to the original, is recognized. But what does section 63 actually talk of when it talks of the document? It talks of a computer output. The computer output which represents the electronic record, which is the primary evidence. Now, what is this computer output? Hereinafter referred to as computer output, it refers to any information contained in an electronic record, but this electronic record need not necessarily be only in electronic form. It can be printed on paper, and if it is in electronic form, it can be stored in any optical media like the CD. It can be in any magnetic media, even our hard disk, you can say, is a magnetic media. It is a semiconductor memory, okay, which may be on a chip, and it may be in a computer or a communication device. Now, earlier, under Information Technology Act, any device which is capable of processing an electronic document was fitting into the definition of a computer, and the processing involved not only changing of the, let us say, binary set, but also storage, transmission, all this was part of processing. Therefore, a communication device was automatically considered as a computer. There was no need to bifurcate this communication device and the computer. In fact, the Supreme Court got confused about communication device and this computer way back in the section 66A decision itself. Section 66A was meant to address the messages sent through a communication device like the SMS or maybe today's WhatsApp and other things, which is actually a one-to-one message. And when a person sends a one-to-one message to another person, he can create harassment, threat, etc. And Section 66A wanted to address that particular offense. Supreme Court was made to understand Section 66A scope in a different manner, and it equated Section 66A messaging with a publication on, let us say, a website. It said that the publication, the message could be have an adverse effect on the freedom of speech. Freedom of speech comes when a person actually publishes some information for consumption by a larger audience, not a one-to-one communication. But Supreme Court took a Twitter as a message under Section 66A, though Twitter as a platform is a publishing, and it also took Facebook publication as a message, and ultimately came up with this Shreya Singhal case, judgment, and everybody thinks it is one of the great judgments of Supreme Court. But I feel that that judgment came, at least as far as this part is concerned, through a misunderstanding of the difference between messaging and publishing, and misunderstanding of a messaging communication device versus the publishing computer device. Okay, now let us keep it aside because we can do nothing, and everybody says that Shreya Singhal judgment is one of the greatest judgments and accepted it, and until another bench of Supreme Court reviews that, it will remain as a very valid judgment. Okay, now here again somebody was thinking that this computer and communication device, why we should simply assume it, we will specify it. So they said that computer or any communication device or otherwise stored, recorded, copied in electronic form. See, ITA 2000 had a unique feature where it defined the whole act on the basis of electronic documents or documents in electronic form. And that could be produced either by a computer or by a mobile or by a device, by whatever name it is called. As long as the document was expressed in binary form, it was an electronic document, and whichever device would process a binary document became a computer. So it was actually a good way of describing what is a computer, what is an electronic document, instead of being specific that the law should be different for mobiles, different for computers. In fact, even a credit card, which let us say has a magnetic strip with data, could be considered under ITA 2000 as an electronic document. So that was the, you can say, flexibility of the definition under ITA 2000. But anyway, here they have thought it necessary to add the communication device, and many people think it is a great innovation. My view is that it was not necessarily required, but let it be there. Well, okay, we'll leave it there. Now, so this computer output can be in any of these form. So which means that information which is contained in electronic record in any of these forms can be called as computer output, and for further Section 63 subsection 2, 3, 4, 5, the Act is going to speak about this computer output. This is very important for us to recognize that we are talking of a computer output, which is a document which is printed on paper, stored, recorded, copied, etc. by somebody who is operating in the 63 environment, which includes a certifier letter. Okay. Now, such document, such computer output shall be deemed also as a document and shall be admissible without the original. So this is what it says. Now, apart from the computer output, the word notwithstanding, I have a slight question mark. Why was it necessary to say notwithstanding anything contained in this Adhiniyam? Because this Adhiniyam contains the evidence includes electronic records, etc. That is equivalent to section 3 and other things. They could have perhaps said, notwithstanding anything contained in this Adhiniyam related to oral evidence or documentary evidence. This section 63 will apply for electronic form. That was the intention. I hope even now that should be considered as the intention, that this notwithstanding in this Adhiniyam is towards notwithstanding anything contained in this Adhiniyam related to non-digital documents. Okay. Now, without further proof of the original, I don't know whether it was necessary, because that is the meaning of a secondary evidence. Now, in the earlier Indian Evidence Act, we said that there is no primary and secondary. Therefore, there was one section 65B document, and that is the admissible electronic evidence. There was no need to discuss primary, secondary. But in this, they have introduced the explanations in section 57, so that we cannot ignore that the law recognizes a primary electronic document. Now, how can this secondary document exclude primary? Okay, because that will only be if the primary document is not available, etc., for which separate section says when is secondary document is admissible. That is when primary is not accessible and so on. So I don't know whether it was necessary, but anyway, it is there. Now, electronic record, we have actually discussed that ITA 2000 defines the electronic record, which excludes the temporary documents, which is another area of concern in the new BNS. Okay. Now, if we come to the subsection 2, the conditions referred to in subsection 1 in respect of a computer output shall be the following. So it is very clear that these conditions of section 63 subsection 2 is in respect of the computer output. Okay. Now, what is the computer output? Computer output is produced by the person who has to produce a certificate under section 63. Now, the computer output, now what are the conditions? Now, this computer output has got certain, let us say, parameters, like the computer output containing the information was produced by the computer or communication device during the period over which the computer was used regularly. So there is something about whether this device which produced the computer output was being used regularly, and whether it was being operated by a person having lawful control. So those are the 2 points in this subsection A. Subsection B, during the said period, the information of this nature was being used or fed into this in the ordinary course of said activities. We'll come back to this. Then subsection C, throughout the material part of the said period, the computer communication device was operating properly. And subsection D, the information contained in the electronic record reproduces or is derived from such information fed into the computer or communication device in the ordinary course of said activities. Now, if you take my argument that section 63 subsection 1 talks about something called a computer output, and section 63 subsection 2 talks about the conditions when that computer output is admissible for further processes, then we are talking of not the primary document, but the one which is produced as a secondary certifiable document for the purpose of admissibility. So this secondary document is a copy of the so-called primary document. Now, let us say the primary document is the Facebook page. Now, you cannot bring the Facebook owner for certifying that his Facebook computer was working properly during the some period, etc. Okay, so that is a primary document which is lying there. Now, the person who is taking the computer output is making a copy of that into his computer, which means that the computer output is being operated in the computer of the observer. Now, the computer of the observer may be the same as the computer of the litigant. That is different. Okay, let us for the time being say that the computer output is being generated in a computer other than where the primary document resides. And it is that computer which has to be regularly used for the purpose of such operations. And that owner should be the one who is available. If I am the observer, I am the owner of my computer. The reason why this ownership is brought in is because there should not be any hidden software, virus or something which even without my knowledge makes a change in the document. You know that there are many viruses which actually make changes in the documents in the background. So when you are seeing the screen, you are seeing something, but before it is produced on the screen, actually it might have been altered. Okay, so the website may contain something, but what you see on your computer may be different if a particular virus is there. So to ensure that the person who is observing and giving a certificate is in control of his computer and he can certify that my computer is working properly during the time of the computer output being produced, there is this lawful owner kind of a requirement. Now, this in this section 63(2), therefore, the computer producing the computer output is the focus. Now, that is the computer which should be a device used regularly. That is the device for which we are talking of the person having lawful control. That is the computer which we are talking of in said period. Now, the said period is what? The said period is for production of the computer output. See, if inside the primary document, let us say we are talking of a 10-year bank statement. So you are looking at ICICI Bank server, a particular account number, and then it is showing 10 years statement. Now, I am not trying to say that over a period of 10 years, the ICICI server was working properly, etc., etc. I don't have the power to certify that. Only the ICICI Bank person has to certify that. And even there, over a period of 10 years, there may not be a single person who can certify that. So what this section 63(2) said period refers to is the period in which the computer output is produced. How does the computer output is produced? One, I get the primary document on my computer, let us say by going to www.facebook.com, entering the particulars, and the page is coming on my computer. Now, once it is there on the computer, I say Control P or something like that. I print it or I copy it into my pen drive or something like that. So the output is produced within that few minutes when the computer generated primary a copy of the primary document is converted into another copy which may be stored on a device or it may be printed out, because both printout as well as this stored this thing could be considered as computer output. So said period refers to this short period in which the person can say, yes, in this 5 minutes, my computer is working properly. Okay. Now, unless we appreciate that section 63 subsection 1 defines the scope of this entire 63, we will not be able to interpret the section 63 2 etc. properly. Many of us think that this computer output we are referring to the primary document. Therefore, I should get a certificate from the Facebook owner or a server owner. That is not feasible. So I am saying it is not correct for the reason that it is impractical to get website documents being certified by the web servers. Okay, so that is what I would like to mention about section 63.2. Now we come to section 63 subsection 3, which tries to expand or explain the scope of what is a computer. Okay, whether the computer means one single computer, or whether it is working in the standalone mode, or it is a computer system, or it is a computer network, maybe even a cloud. Okay, computer resource enabling information creation or providing information processing and storage. When you go into the cloud, you know that there is a cloud platform, there is a cloud application service provider, and a multiple set of people. Then lastly, this subsection E of section 63.3 is very interesting, and this is another aspect which could create lot of legal problems. Just like this defining that there can be multiple primary documents, this is another thing which can create a problem. What it says that where during any period the function of creating, storing, processing information for the purpose of any activity, which is the activity we are talking of, activity is producing the computer output. Okay, because activity regularly carried on over that period as mentioned in subsection 2. Okay, if it is done by more than one computer, for example, I have my computer, I connect it to my printer. My printer is also a second computer. So printing itself has got two devices. And if it is a network, from my network device, it may go to a central server. From central server, it may go to a printing server, and printing server may print out. So there may be multiple devices involved. So that is what this is talking of. This or through an intermediary, what it means is that this one of the computers can be an intermediary. Who is an intermediary? Intermediary is a third party. See, if I have a company, let's say I'm using a cloud printing service. I give a printing instruction sitting here, and some XYZ company will print it and blink it or something like that. And next 1 hour, they will come and deliver it to me. So there are such services. Okay. Then otherwise, let us say I have got a photograph. Now I want to capture the metadata of that photograph. I send it to a website online, and that website adds the metadata about the photograph and then sends it back to me. In which case also I'm using in this activity of observation an external intermediary. There may be many other such cases. Now today there are a lot of online devices, including if you want to save a website, a web page into a PDF. Now, if you don't have a converter or in your computer, you may send it to some this thing and website and then get a PDF copy. Or you may have an image, you may want to save it in a compressed form. You may use it, or you may want to change the format of the image from TIFF to, let us say, something else, from PNG to JPG. You may use an external listing. So there are many cases where a user can use an external company for completing the process of capturing the so-called certifiable computer output. Now, section 63 says that is also admissible. Now, the question is, we are talking of an intermediary who is outside my control. So then I am actually trying to trust that particular intermediary not to have made changes or modified the information which I sent it from here to there and before he sent it. Now, if this intermediary is allowed, there is one more issue. In the earlier case, in one of the Orissa cases, under section 65B, there was a situation where it was an election case in which the videographer had captured certain video which first went into the camera's chip, and then from that camera chip this person had copied it into the videographer's own computer, and then from there he had transferred it to a pen drive, and perhaps the pen drive was given to the election commission, and election commission then saved it on their server. And when the dispute arose, the election commission was producing whatever data, which electronic document, which was a video, which was in its possession. In that case, the question came that this video has been transmitted from one device to another device several times. Then who is responsible for any modifications which might have occurred in these transmissions? That is when the court said that whenever such things happens, we need to have a contemporaneous certification under section 65B before a document is shifted from one container to another container. Now we are talking under section 63(3), an intermediary. Now I am shifting my data to the intermediary. Intermediary is a subcontractor, a third-party processor, and I am requesting him, please process it in a particular manner and return it to me. Okay. So, and then he returns it to me. Now, it should perhaps have two contemporaneous certifications, one before I send it to him and another by him before he sends it back to me. Otherwise, we are considering the intermediaries process as part of my process, which is actually extending the trust to an unknown party. So I feel this is slightly incorrect. And of course, I can always say how it can be done. Now, all those service providers whose services the observer is using for producing the let us say the computer outputs should be trusted agencies. Whenever I used to handle section 65B certifications, if their software is required for that purpose, I used to say that I should be having a licensed copy of that software in my computer. And I should claim that I am the owner of that computer, that particular software. And then I route this electronic document through that resident application and then get the output and certify it as coming out of my computer. Okay. So in this particular case, similarly, now if I'm entrusting it to a third party, that third party should be a trusted person, and he should give me an assurance certificate saying that I have not made any changes either knowingly or unknowingly in this document. I have just processed it the way you wanted it to be processed. I have sent it back. So there has to be a kind of an assurance certification from this intermediary. So this should have been spoken of in the, let us say, the procedure for this. Now we'll come to section 63(4). Okay, this is about the certification. What should be the contents, etc. In any proceedings where it is desired to give a statement of evidence by virtue of section 63(4), which is producing a computer output and certifying it, then it shall be submitted along with the electronic record at each instance where it is being submitted for admission. And these are the things which are required to be done. One is identifying the electronic record containing the statement, then describing the manner in which it is produced. it is very important to record the manner of production in as much detail as possible, so that somebody else, if they follow the same manner, they should more or less get the same electronic record, or explain why there is any small difference. Okay, so this is like in a patent application, we say that the patent description should be such that any person with a reasonable understanding of the technology should be able to reproduce it, and he should arrive at the same result. Same kind of requirement should be considered here when we say describing the manner in which it was produced. In a simple case, of course, the manner it was produced is you open the computer, you go to a particular folder, you open a particular file, and behold, you have that in front of your computer, you print it out. Okay, that is a simple process. In another process, you open the computer, you open an application called browser, and then you type the URL www, etc. in the window, and then computer should be connected to the internet. Then you click enter, and the computer will take you through the internet service provider to that website and display a particular page. And that page, you take a printout or do whatever is done. That is the process. So once I describe this process, if somebody else takes his computer and does the same thing, he should ideally get the same result. But I've always been telling that websites are different, because website recreate a dynamic page at any point of time, and sometimes that changes. They will changes maybe only in the advertisement. It may also be in the content. It all depends. Suppose a person is coming from India, a certain content is maybe produced. If a person is coming from elsewhere, from USA, content may be slightly different. So this is inherent nature of a website. So accepting that, if a person from India had given a certified copy and another person from India, maybe from the same location in Bangalore, is trying to log in and see the page again, more or less he should get the same page, except that yesterday's advertisement may be actually replaced with today's advertisement. So there also there can be some kind of a change. Okay, so that is the question of describing the manner of thing. Now the other subsections, giving particulars of any device involved in the production of that electronic record, because again this description should include this device, because the device can be a Windows computer, it can be a Apple computer, it can be a mobile, something like that. Okay, so giving the particulars of any device involved. Then dealing with any of the matters to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person in charge of the computer or communication device and an expert. So earlier it was only the observer who was signing. Now they say that it should be signed by the computer owner as well as the expert. Now, if there is an intermediary, if there is a multiple computer, does it mean that multiple computer owners have to sign this certificate? Okay. Now, if you don't recognize that we are talking of one computer output, and that one computer output is the final document which is visible to the observer after whatever processes have been done in one or more computers. If you recognize that, then there is only one document, one computer from which it is easy to take the certificate. But if you say, no, this document is produced by multiple computers, then the question that multiple people will have to sign this certificate becomes necessary. Okay, so if it is done like that, it shall be the evidence for the particular purpose of this section 63. Now, some comments which I have written on the right side. Contents of the certificate, evidence record needs to be identified. Now, what is that which we are going to identify under section 63(4)? Identifying the electronic record containing the statement and describing the manner. Now, does it relate to this computer output, identifying that this is the computer output dated so and so, which I have signed? That is one aspect. Or does it refer to the web page which I am trying to copy or something like that? Is something which you can discuss. I feel that this refers to the electronic record, which has to be the piece of evidence, and that cannot be produced in a primary form. Therefore, we are converting that electronic record into the computer output format, and therefore have to describe that particular, identify that particular document, and then go ahead. So contents of the certificate, this evidence record should be identified. And now the question comes about the hash value, which is also referred to in the annexure when we come to that. Now, it says that, say, if there is an electronic document, you can calculate the hash value. But if it is a printed document, there is no hash value for the printed document. Now, computer output can be in printed form. That is, if the matter which should be admitted as a fact or a statement is a text matter, you can take a printout, and that is a faithful reproduction of what a statement has to be. And therefore, there is no problem in producing the paper printout with a physical signature without a hash. This is what was happening in the section 65B. Now, somebody who wrote this section made it look as if hash value is required for every electronic document which is being certified, whether it is in paper form of computer output or electronic form of computer output. Say if there is a video or an audio which you cannot print out, then it is essential to calculate the hash value. But if you are producing a section 63 certificate for a video or audio, then this whole certificate has to be attached with an electronic document, which means that section 63 certificate, this computer output, which can be produced either in electronic form or printed form, has to be produced only in an electronic form. And then the audio or video should be attached. What you can create in paper is only a covering letter. I am enclosing here with the section 63 certificate in respect of the video which was present in such and such a computer, etc. Hash value of which is so and so. All that can be done provided the entire section 63 certificate is produced in electronic form. But if it is produced in paper form, which is feasible in the case of paper, text matter, then there should be no requirement of a hash value, because you cannot create a hash value for the text portion. For example, you take the case of this Suhaskati case. We were looking at a Yahoo group message. Now, how do we calculate the hash value for that message? I have to cut and paste that particular message into a text document and then calculate the hash value. When I cut and paste it in text document, I may lose formatting. Okay, I may lose coloring of the fonts, etc. So that is not a proper reproduction. So what I have to do, I have to take a screenshot. Now, if I want, I can take the screenshot in electronic form, which is, let us say, JPG, and I can calculate the hash value of that, and then create an electronic section 63 certificate enclosing that screenshot in electronic form. Otherwise, if that is only the text which is a factor, I can take a printout of that screenshot, in which case I don't have to give a hash value. Okay, this is my view, and we have to see how we will handle this in the future. Now, in the case of a video or an audio, the audio cannot be printed. Therefore, it has to be captured in electronic form. You can calculate the hash value. You can state the hash value in your written statement, saying that I'm enclosing here with a video whose hash value is so and so. But the main certified report has to be in electronic form, and you have to digitally sign that form. You can have this covering letter physically signed, but electronic annexures has to be signed only in the form of an electronic section 63, which has to be digitally signed. Okay. Now that is about the contents, and the device referred to here. If we say that entire section 63 is about computer output, we are talking of the device which is producing the computer output. So the next question is, the certificate needs to be signed by the person who owns that device which is used for computer output, and an expert. Now, the person who is actually producing the computer output himself may be an expert. See, it is not necessary that in every case of admittance of an electronic device, you have to get a section 79A accredited person. If that has to be done on a daily basis, maybe thousands, maybe lakhs of electronic evidence in multiple courts in the country will have to be certified. We have only 7-8 FSLs who are certified or accredited for section 79A. It will not be possible for them to actually produce this kind of a certification. So that is not the legislative intention at all. And even if there is a section 79A certified certifier in my town, I should be able to bring a private expert who submits this for admissibility. And after it is admitted, if there is a dispute, then the court can request the section 79A digital evidence examiner to come to the court and help the court in understanding whether the section 63 certificate given by the private expert is acceptable or not, because the defendant has challenged it. Now, defendant can challenge it only after admissibility at the genuinity stage. So this involvement of this expert from the forensic lab can come at the time when genuinity of the question is of the document is in question, or when there are two section 63 certificates for the same electronic record which do not agree with each other. So in that instance also, the court can say that both are experts, both have signed these things, both of them have given it in good faith, hopefully not maliciously, because if they've given it maliciously, then they become liable for perjury. Okay, but let us assume that both of them honestly have given the certificate, but there is a difference. Then they can ask a digital evidence examiner to come and help the court. So when we say expert, the expert is any person who has got a sufficient technical knowledge for the purpose of making that statement, which is the computer output and the certification of that. And it can always be overridden by the court's own digital evidence examiner, and digital evidence examiner may certify something based on which the court may take a decision that I agree or I don't agree with a particular certificate. So that is what is required. In fact, it may be necessary in due course for the Ministry of Information Technology Act to create a set of accredited Section 3 certifiers different from the digital evidence examiners, which are the 8 or 10 CFSLs, which are presently notified, who can continue to help the courts. But for the individuals, if you want to say that every litigant cannot go to some Tom, Dick, and Harry and ask for certification, that of course sometimes it can be handled at the court level, because the court which is accepting the admission may ask who is this person, what is his credentials, whether he has got the relevant credentials or not, and also try to tell either the petitioner or the certifier that in case I find that your certificate is malicious and wrong by design, I may hold you responsible for perjury. Then that is one way you can filter any malicious certificates. Otherwise, I feel that an organization like MIT should try to create a set of people who can provide Section 63 certification. They can be trained specifically more than the training. Their credibility is to be checked. But I think this is something which has to be done in order to ensure that there are more experts than currently certified accredited digital evidence examiners. Okay. Now coming to the last subsection 63.5, basically it says that that for the purpose of this section, information shall be taken to be supplied if it is supplied in an appropriate form, whether it is directly input by a person who is typing on the keyboard or by any other means. Okay. Probably this would cover the use cases like when a computer picks up information from a sensor and automatically takes into the system for processing. Similarly, CNC machines, servers who all act automatically. Just to cover that, the section 63.5 is there. So this is the explanation of section 63 subsections 1 to 5. Now, if this act also provides a schedule of how a certificate can be given. Now, some people say that this adds to the clarification. It is now easy. We know how to give certificate, whereas earlier there was no such specific format. My feeling is that by specifying part A and part B and saying something, you are adding more confusion and more perhaps difficulties than leaving it open for an informed certifier to develop his certificate and for a judge to accept it. For example, if you look at any of the sections, 65B certificates I had given in the last 1 or 2 years. Of course, I should admit that from 2004 to today, the way I have been given giving certificate also has evolved. Okay. Now, the latest certificates, which of course presently I have stopped giving such certificates, and I have asked one of my associate to do that. I don't issue such certificates. But if you look at some of the recent certificates which I have issued, these certificates are a booklet, a kind of say a report, because that report contains one annexure, which is the electronic document which is under dispute, which we want to prove, or whoever wants to prove. So that may be one or many pages of a website. Let us say there are 25 pages of a website which is a point of dispute. Then all those 25 pages will have to be there in the annexure. That is the main content which needs to be captured. So because I am talking of a website, I can take a printout and put it as a print copy. If it was an audio video, it has to be in the electronic form. Okay. Now, this particular set of electronic documents have to be identified, and then the process of how we arrived at that has to be captured. Now that process involves, let's say, going to a particular computer, going to the website or something like that. Or if it is the case of a corporate computer, there is only an authorized person who can enter it. So I should ask him to enter his password and open the page and show it to me. I am not taking the password and doing it. He will open it. I have to record that so and so, who is an authorized employee of the organization, opened this page and showed it to me, kind of a thing. Then I will continue to see what is there and taking pages after pages as screen shots, so that the entire process of entering the computer to reaching a disputed, let's say electronic document is also captured by a series of screenshots. Similarly, the computer identity, I have to go to the device details. and then capture that straight away. Instead of my typing this computer belongs to so and so, I normally go there and then check that. If you go to a mobile, then we look at the IMEI number, we enter the code and get the IMEI number and capture the screenshot as it is. Okay. In statement, I may still reproduce it as IMEI number so and so, but there has to be an evidence within the report. So apart from the 2025 electronic documents, which are the subjects of the certification, there would be several other documents which actually express the procedure through which those documents were created. And therefore, my reports normally are will have annexures which are big. First few pages, of course, will talk about the certification requirements, which will talk about the name of the person who has asked me to do this and the uh, device which was offered for certification, and to say that this is to certify in good faith and kind of a thing. So that part is the initial part. But most of the time in my certificates, I also add an annexure on my own credibility, who I am and what I have been doing, kind of a thing. So therefore, the CEAC certificate report, which I used to produce, used to be a booklet. Now, I have designed it on my own. I hope that if a judge is looking at it without my presence there, he can read from beginning to end. He can understand most of the things. And in the latest these things, I even used to add an signature verification data there. That is, I would have signed the document in physical signature. I would provide a digital signature for verification using the PAN card and other things. So I had devised my own method of doing that. And in the case of videos and audios, I used to calculate the hash value, and in the reports say that the hash value was calculated, and I used to have an electronic copy of the whole report in addition to the printed copy. In the printed copy, only the report would be there. Annexures would maybe not there. Or in the case of video, I used to take some periodic screenshots and show it so that it can then be compared with the running video later on. But apart from giving it in print form, I mandatorily give it in electronic form, where the hash value is more relevant, and with a digital signature, I used to issue. Now, this particular BNS talks of just 2 pages, part A and part B, and I am sure that many people will uh, perhaps think this is the only certificate or information to be given. Now, where is the reference here for the annexures, which has to talk about the details? That is a question which will come. It only talks, for example, the first part of that part A is for the owner. Okay. Second part is for the expert. Now, it would have been enough if the hash value is mentioned only in the experts this thing, so that the owner could have only certified that it was his computer which was being used for developing the computer output. But now it says that he also has to calculate this hash value, and then this person also has to calculate the hash value. Obviously, the two hash values will have to match. Okay. So it's a duplication actually. We have to wait and see how this will work. Now, if the computer owner is an illiterate person or near illiterate, then whatever he signs there with hash value and other things has got zero meaning, because we cannot expect him to understand what he's writing above. Of course, you can say that this is my mobile. I am so and so, son of so and so. He can state, okay. And then this mobile with this serial number or SIM number is mine. That is a simpler thing which anybody can, even a less literate person can certify. But the moment you go into, I state that the hash value of the electronic or digital record is so and so, then we are getting into a problem, particularly if there are multiple electronic documents. I told you 25 pages of website. then there has to be 25 documents and 25 hash values. There cannot be one single hash value. Now, all these issues will be there as far as the certificate Part A, Part B is concerned. I hope this will be treated as optional, and whatever certificate is given, if it contains all this information, I think it should be okay. Earlier, the owner of the computer used to come as a person who will submit the expert's uh, certificate in his own affidavit. Say, if I am producing the Section 65B certificate, I give it at the request of XYZ. I am giving it to him, and that litigant will submit with his affidavit to the court saying that I have obtained an expert certificate on Section 65B, and therefore his signature comes in the covering letter enclosing my report. So he was also a party to the confirmation. Now, what this BSCA says is that he should also sign here, but a person who may not know the entire process and other things, I'm sure that his certificate is of very little value, because in cross-examination, if you ask him, what is this Shavan, this thing you have signed, he will have to say, I don't know. Okay, even experts will be confused when you say, what is SHA-1 and what is SHA-256, why you did not go for MD5 or something like that. I think, and whether it's a legally acceptable standard, who is going to define that? Somebody has to go to the CCA website and look at it, or somewhere like that. So all that the ordinary litigant is not expected to know, because he is not the expert. If he is the expert, there is no need for somebody else to sign. Okay, he can even produce his primary document. What is the primary document? Now the question is, what is a primary document? See, many times people think that the device is the primary document. Okay, so somebody may say, I will submit my mobile, so don't ask me for any certificate. And when a police, sometimes they seize the whole computer and produce it. Okay, now in reality, the device is not an electronic document. It is a container of an electronic document. So it is very important for everybody working with Section 63 to realize that what is required as evidence is an electronic document, not the container of the electronic document. Suppose in the case of a murder situation, police go and seize, say, murder weapon with maybe let us say a gun or a pistol or anything else, and in the house they found it in an almirah. Okay. So in the report, they will say, I found this in the almirah and produce only the gun. And if there are any unused bullets, they may produce it. They may say unused bullets were in a different place. That also we have submitted it. So the evidence objects, exhibits will be the gun and the unused bullets found in the premises of the accused. But they don't bring the almirah there. They will be saying it was contained in the almirah. Now, if there is a hard disk, within the hard disk there is a defamatory statement. That defamatory statement is the electronic evidence, not this whole hard disk. You may still say that in the computer output production, you may say that this evidence was present in a computer hard disk so and so number, etc. Okay, that is okay, like saying that the gun was found in the almirah. Okay, but it is not to be treated, that is, the hard disk should not be treated, or the computer should not be treated, or the mobile should not be treated as an electronic evidence and produced as primary evidence. So if you accept that, now tell me, how do you produce a primary evidence? A primary evidence can only be produced as a copy, which is the computer output we are talking of. So the earlier Section 65B, which did not talk about primary and secondary and only said electronic documents can be admissible as per Section 65B, was a better way of talking about Section 65 electronic evidence. Today, when we are talking of Section 63, by bringing in the possibility of a primary document, we are completely confusing the people. Now, I'm sure that the devices will be dumped with the court, and say that here is a primary document, so don't ask me for certification. Now, then what will happen? The judge will have to open the computer, then he has to open the particular folder, he has to go to a particular thing and then read. Now, then he has to take a view of the content, which makes him the substitute for Section 63 certifier. The whole concept of Section 65 certification was that electronic documents are not reliable on their own. What you see is not what could be the real content. I've always been telling that electronic document is a binary document, and if you are using a particular type of software to view that, it will give something like that. For example, if you are having a Word document and the fonts of the document is, let us say, in Kannada, if you are using an English software in font, you will obviously not be able to read that document. So you have to use a Kannada font. That means that the person who is observing should make a decision that, okay, when I opened it with my regular font, it is not coming up. Now I have to find out which font I should use. I should go to the menu for Word and then choose a particular font. Now there, if I choose a Telugu font instead of Kannada font, I may get something else. So therefore, in viewing an electronic document, even when it is present in the primary device, there is going to be a lot of discretion used by the judge. And because of that, judge becomes the witness and he will lose the status of being a witness and a judge at the same time. So it should always be necessary for a third party expert to provide a Section 63 certificate, even when the original device, the so-called original device, is handed over to the court. The court should ask somebody to own the electronic document and then give a certificate saying that when I opened this computer, when I did the XYZ, I got this particular document, which I am giving it as a copy under Section 63 certification. Then that person becomes the certifier. And tomorrow, if he gives a certificate maliciously, you can hold him responsible for perjury. Otherwise, you take him as a person who is assisting the court in trying to bring the computer document into a kind of normalized document which the court can view. It is in a different currency. You want it to be converted into the currency which you can use. So you tell him that you please open the computer, give me the document. I only have to see whether that document content is defamatory or not defamatory. Rest of the things you certify that it was contained in this computer. You certify that this computer belonged to so and so. Therefore, I will presume that this person is the owner of that. Those are all the things which the IO or the person has to prove. And if I'm accepting that, I will accept that this document belongs to this particular person, and then I will take a view on the content. So that is how things have to be done. You should never look at a device as an electronic document. These are some of my specific thoughts, which I have explained in many other cases, and I will continue to do so. Probably there could be differences of opinion. I will be surprised if there are no differences of opinion with experts, but I would like to place this view for the larger audience to consider. Thank you. In case you have any questions, you can always direct it to me. You can go to naavi.org, naavi.org, or you can send it and find my contacts there. Or, of course, you can always send an email or something to me. Thank you, friends.